So this is a continuation of the report by uh, Mr. Bumakil about the real estate mortgage law. The contents of my report in continuation of said report by Mr. Bumakil talks about the procedure in a real estate mortgage foreclosure, specifically where to file, where to sell, what are the posting requirements, and the publication requirements as such. We'll also talk about the possession by purchaser of foreclosed property and what are the remedies of a debtor if foreclosure is not proper. So those are the topics which are the contents of this report. So first of all, uh, where do you file? And our law says that all applications shall be filed with the executive judge through the clerk of court, who is also the ex-officio sheriff. And it also important to note that we file it in the province where the property is situated or located. So basically, sale cannot be made legally outside of the province in which the property sold is situated or located. If the venue is subject to stipulations as well, such sale shall be made in said place or the place where the parties stipulate, or in the municipal building or the municipality in which the property or part thereof is situated. Now we come to the posting requirements. The notice of the sale is posted in at least 3 public places of the municipality or city, or sheriff's office, that would be in the sheriff's office, assessor's office, and the register of deeds, where the property is situated, for not less than 20 days and published once a week for at least 3 consecutive weeks in a newspaper of general circulation in the municipality or city. Posting of notice on mortgaged property is not required. Failure to advertise a mortgage foreclosure sale in compliance with statutory requirements constitutes a jurisdictional defect, and the result is it invalidates the sale. A substantial error or omission uh, of the notice of sale will render the notice insufficient and will vitiate or invalidate the sale. As for publication requirements, first of all, what is a sufficient newspaper publication? Um, Notice shall also be published once a week for at least 3 consecutive weeks in a newspaper of general circulation. So a newspaper of general circulation need not have the largest circulation so long as it is of general circulation. So it is enough that it is published for the dissemination of local news and general information, that it has a bona fide subscription list of paying subscribers, and that it is published at regular intervals. The newspaper must not be devoted to the interest or entertainment of a particular class, profession, trade, calling, race, or religious denomination. The newspaper need not have the largest circulation, so long as it is of general circulation in the municipality or city where the property is located. So this basically describes uh, what is a newspaper of general circulation. Need for republication in case of postponement. So in case there is postponement, there is a really need for a republication. Republication is necessary for the validity of a postponement of postponed extrajudicial foreclosure sale. Another publication is required in case the auction sale is rescheduled, and the absence of such republication invalidates the foreclosure sale. The last paragraph of the prescribed notice of sale allows the holding of a rescheduled auction sale without reposting or republication of the notice. However, the rescheduled auction sale will only be valid if the rescheduled date of auction is clearly specified in the prior notice of sale. The absence of this information in the prior notice of sale will render the rescheduled auction sale void for lack of reposting of publication. So this is the case of Bautista versus Premier Development. So this illustrates the previous concepts which we discussed about republication. So spouses Bautista are the registered owners of the parcel of land located in Rizal with an area of 1,248 square meters, and it's covered by a TCT number which is registered at the Registry of Deeds in Marikina City. So on January 1994, spouses Bautista obtained a loan of 500,000 from Premier Banking, for which they executed a corresponding promissory note. So to secure the performance of their obligation, they also executed a real estate mortgage over the above stated parcel of land and its improvements. So for failure of spouses Bautista to settle their obligation in full, the sheriff sent the first notice of extrajudicial foreclosure sale to them in October of 1995, informing the mortgage property would be sold in a public sale to be conducted on November 17, 1995. So the spouses Bautista requested the postponement of the scheduled sale as well as the detailed computation of their outstanding obligations several times, as borne out by the exchange of letters between them and the Premier Bank. Uh, on December 6, 2001, the sheriff prepared and sent notices of extrajudicial foreclosure sale to be held in January 15 of 2002. The notice was published in the Challenger News, a newspaper of general circulation in the province of Rizal. Um, However, the sale did not push through as scheduled because the representative of the Premier Bank did not appear and was rescheduled to February 18 of that same year, 2022. So although the publication and posting of the notice of their scheduled date of February 18, 2002 were made thereafter, the sheriff conducted the foreclosure sale on February 18 and struck off the property of the spouses Bautista to Premier Bank as loan bidder. Um, the sheriff issued the certificate of sale in the name of Premier Bank, and the same was annotated on the original copy of the TCT um, on November 7, 2002. The statement of account indicated that Bautista's outstanding obligation totaled to 2,062,000 as of February 18, 2002. So spouses Bautista redeemed the property within the required period by tendering the amount of 401,820. So the sheriff then issued the certificate of redemption in their name, but Premier Bank refused to accept the redemption price because their total unpaid outstanding obligation has accumulated to over 2 million. Uh, so Premier Bank then consolidated its ownership, and the Register of Deeds of Marikina City issued a TCT number in favor of said bank. So on November 6, 2003, spouses Bautista sued the respondents in the RTC to seek the annulment of the shares foreclosure sale held on February 18 on the ground of the failure of the respondent to comply with the mandatory and jurisdictional requirements of publication and posting of the notice of sale in accordance with Article 3.1 3135. So on February 8, 2008, the RTC rendered judgment dismissing the complaints of the spouses, and the CA also affirmed. So the issue in this case is whether or not the Court of Appeals erred in declaring that the extrajudicial foreclosure sale was valid despite the failure to publish and post the notice of their scheduled foreclosure sale. And the Supreme Court said yes. The requirements for posting and publication under Act Number 3135 are mandatory and jurisdictional. The court held that statutory provisions governing the publication of notice of mortgage foreclosure sales must be strictly complied with. Hence, even slight deviation from the requirements would invalidate the notice and render the sale at least voidable. The objective of the notice of requirement is to achieve a reasonably wide publicity of the public sale so that whoever may be interested may know of and attend the public sale. This is the reason why the publication must be made in a newspaper of general circulation. The court has previously taken judicial notice of the far-reaching effects of publishing the notice of sale in a newspaper of general circulation. As such, the publication of the notice of sale in a newspaper is essential to the validity of the foreclosure proceedings. To allow the parties to waive this jurisdictional requirement can convert it into a private sale, what ought to be a public auction. So this is the decision of the Supreme Court on this issue of lack of notice of the rescheduled foreclosure sale. So the next topic is personal notice to the mortgagor when and when not needed. So the general rule is personal notice to the mortgagor is not generally required. The exception is, unless required in the mortgage contract, the lack of personal notice to the mortgagor is not a ground to set aside a foreclosure sale. So unless otherwise stipulated by the parties to the mortgage contract, the debtor mortgagor need not be personally served a copy of the notice of the extrajudicial foreclosure. And possession by purchaser of foreclosed property. So upon failure of the debtor to redeem the property within 1 year, so that's the period of redemption, after the date of the registration of the certificate of sale, the winning bidder becomes the absolute owner of the property. Okay, so the last topic is that what are the remedies of debtor if foreclosure is not proper? So if the foreclosure procedure does not follow the rules which they're supposed to follow, as we discussed previously, what is the remedy of the debtor? So the remedy would be within 30 days after the purchaser is given possession of the property, the debtor may petition that the sale be set aside on the ground that the mortgage was not violated or the sale was not made in accordance with the provisions of Article 3138. This may be done in the proceedings in which possession was requested. So basically, if the winning bidder is able to secure possession, the mortgagor may petition that the sale is set aside and the right of possession be cancelled on the ground that he wasn't in default or that the sale wasn't made in accordance with Article 3135, and this must be filed within 30 days from the issuance of the writ of possession. So that is the remedy of a debtor if foreclosure is not proper.